Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, with the Supreme Court's complete unwillingness to review assault weapon bans and magazine bans, we had predicted that there would be an extreme amount of civilian disarmament push in many of those states that are hell-bent on disarming their citizens now that they believe that they really have carte blanche to ban whatever they want, that the Supreme Court is really not interested in reviewing those otherwise unconstitutional bans. Case in point we're going to talk about today is one of the two states where their case got denied by the United States Supreme Court. That's the case of Rhode Island, because now it appears, well, they have their own assault weapon ban and it's already passed out of the House. So today, let's spend a few minutes and let's talk about the states doubling down on firearm bans. Okay, America, I have a feeling that we're going to end up doing a bunch of videos about this. They will be state specific, but we're going to see a rash of assault weapon ban, magazine bans, Glock bans, any kind of ban that a civilian disarmament state could come up with. Why is that? Well, because the Supreme Court has indicated that they really have no interest in reviewing any of those. Case in point, the bill that we're talking about today is Rhode Island H5436 Substitute A. This is a piece of legislation which is entitled the Rhode Island Assault Weapon Ban Act of 2025. That's right. Now that the state of Rhode Island feels completely emboldened by the Supreme Court's unwillingness to review their magazine ban, and now they are going to remove semi-automatic rifles, semi-automatic shotguns, some pistols from the purview of Rhode Island residents. Okay, what we're going to do today is we're going to break the bill down for you, and I know that everyone's going to have these questions, so we're going to do it in this order. What we're going to be talking about today is, number one, what does the bill ban? Number two, when would the bill take effect? And number three, what happens to the stuff I already own? Because many of you may own what you refer to as a semi-automatic rifle, and the state of Rhode Island is now going to refer to as an assault weapon. Okay, what does it ban? According to the legislation, Rhode Island will define an assault weapon ban as any one of the following firearms: a semi-automatic shotgun with a fixed capacity exceeding 6 rounds. 2, a semi-automatic shotgun that has the ability to accept a detachable magazine and has at least one of the following features: a folding or telescoping stock, a pistol grip or thumbhole stock. Any feature has the ability of functioning as a protruding grip that can be held by the non-trigger hand. Then we get into the rifles, and there are going to be 2 classifications of rifles now which will be deemed assault weapons by the state of Rhode Island. They include a semi-automatic rifle with a fixed magazine capacity exceeding 10 rounds, and a semi-automatic rifle that has the ability to accept a detachable magazine and has at least one of the following features. I want you to understand that some states is a semi-automatic centerfire rifle which accepts a detachable magazine. This is only a semi-automatic rifle which accepts a detachable magazine, and if it has any one of the following features, which it will, it would then be a banned item. Those features include a folding or telescoping stock, a grenade launcher, a shroud attached to the barrel that partially or completely encircles the barrel, allowing the bearer to hold the firearm with the non-trigger hand without being burned, a pistol grip or thumbhole stock, a flash suppressor, a threaded barrel. But then again, I want you to understand, Rhode Island, if you think it's just the scary rifles that are getting banned, au contraire, because the legislation also defines certain pistols as now assault weapons. A semi-automatic pistol has the ability to accept a detachable magazine and has at least one of the following: the ability to accept an ammunition magazine at a location outside of the pistol grip, a threaded barrel that has the ability to accept a barrel extender, flash suppressor, forward hand grip, or silencer, a shroud that is attached to or partially or completely encircles the barrel and permits the shooter to hold the firearm with a non-trigger hand without being burned, a buffer tube, arm brace, or other part that protrudes horizontally behind the pistol grip or allows or facilitates firing the weapon from the shoulder. So clearly they are banning the AR, AK style pistols, but there could be some regular handguns that could also fall into this category, so please be aware of that. Oh, and then any firearm which is belt fed, that too will be defined as an assault weapon if this bill becomes law. Okay, so now that we know how the bill defines the prohibited weapons, what activity is also banned if this bill becomes law? Rhode Island, you need to pay attention to this. Except as provided in subsection D and E of this section, on or after July 1st, 2026, no person shall manufacture, sell, offer to sell, transfer, purchase, possess, or have under his or her control an assault weapon. Any person convicted of violating this subsection shall be punished by imprisonment of not more than 10 years or by a fine of up to $10,000 or both. Okay, so unlike the assault weapon ban that got shoved down our throat out here in Washington State a couple of years ago, which only banned the commercial sale, this bill actually bans the possession. Does that then mean that if you currently own one of these items, you will be forced to surrender it? The answer is no, you won't, so long as you register the firearm with your state and get, this is no joke, a permit to possess that firearm. So in addition to an unconstitutional ban of in common use type of firearms, we are also going to create an unlawful registry. And even though the state of Rhode Island in this bill says, oh, well, we're not going to keep all the data, what's the purpose of collecting it to begin with? Until July 1st, 2026, the owner of a grandfathered assault weapon who is not otherwise prohibited from possessing a firearm may apply for a voluntary certificate of possession from the Rhode Island State Police or the police department where the person resides. Any person in possession of multiple grandfathered assault weapons before July 1st, 2026 may submit separate applications to obtain a voluntary certificate of possession for other grandfathered assault weapons in their possession. Now, even though the state of Rhode Island is going to try to claim that they are not creating an unlawful gun registry, let's take a look at the data that would be collected when you get your voluntary certificate of possession. That the certificate of possession contains a description of the assault weapon, including the make, model, and serial number. For an assault weapon manufactured before 1968, identifying marks may be substituted for the serial number. That the certificate of possession contain the full name, address, and date of birth of the person who owns the assault weapon and any other information deemed appropriate, and that each application shall be signed by the applicant and the signature shall constitute a representation of the accuracy of the information contained in the application. And then there is a $50 application fee. So yes, what you have to do, Rhode Island, if this becomes law, is you're going to have to pay money to the state of Rhode Island for you to keep property that you lawfully purchased and lawfully own. That's what's happening here. And then finally, you need to be aware, Rhode Island, that if this bill becomes law, even though you may have grandfathered assault weapons that you are still allowed to lawfully possess once you've registered them with the state, understand that you really just don't get to use them anywhere, because the state of Rhode Island will want to restrict where you can actually possess and use these firearms, because the bill specifically states any person who lawfully possesses a grandfathered assault weapon as provided for in this chapter may possess the assault weapon, 1, at that person's residence or place of business or other property owned by that person, provided that the grandfathered assault weapon shall be kept in a secure storage. 2, while on a target range which holds a regulatory or business license for the purpose of practicing shooting at that target range. 3, while on the premises of a licensed shooting club. 4, while attending any exhibition, display, or educational project which is about firearms and which is sponsored by, and then it's law enforcement agencies, national Second Amendment organizations, educational organizations like that. But there are more restrictions above and beyond that about where you can possess your assault weapon. 5, while transporting the grandfathered assault weapon to any federally licensed firearm dealer for service or repair. Or 6, while transporting an assault weapon for lawful use between any of the places set forth in this subsection. Oh, and by the way, if you're caught even with a properly registered grandfathered assault weapon, but you're possessing it in a place where you shouldn't be, yeah, you face up to 3 years in jail and a $2,500 fine. So, Rhode Island, I just want you to know that all you are right now is next. Next in line to have your state legislature go full hell-bent civilian disarmament on you. And unfortunately, you're the first in what's going to be a long list of states to double and triple down on these civilian disarmament measures. Why? Well, because the Supreme Court has shown an absolute unwillingness to review any of this type of legislation. We already know that they turned down the petitions on Snope v. Brown, the challenge to assault weapon ban, as well as Ocean State Tactical versus Rhode Island, the challenge to Rhode Island's magazine ban. What many of you may have not picked up late last week was another Supreme Court orders list that came out on June 6th. And in that, the Supreme Court just summarily denied the petition of Hansen versus District of Columbia. We've talked about that case before because that was a challenge to the District of Columbia's magazine ban. And the Supreme Court, just like they did with Ocean State, just like they did with Snope, just brushed it aside and said no big deal. And it is for that reason that we are going to see states like Rhode Island and many, many others turn around and double and triple down on these outright bans of weapons and components because they are hell-bent on civilian disarmament. Okay, Rhode Island, it is H5436, substitute A. You don't have to take our word for it. We're going to link it up down below so that you can geek out on it for yourself. I want you to understand that this is already passed out of the House. It's halfway to getting to the governor's desk. So this is a reality. And what I would suggest to you, Rhode Island, is, well, you might want to start stocking up right now. Listen, if you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information down there in the description box. If you got an idea for a video we should be doing around here, cool, we want to hear all about it. Click on that link right there and tell us all about it. If you want to subscribe to our monthly newsletter, you can do that by checking out the information in the description box. And then finally, and most importantly, America, let's everyone remember that part of being a lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.